Good afternoon and welcome to the regularly scheduled meeting of the Oklahoma City Board of Adjustment for January 18th, 2018. Before we call the meeting to order, just a couple of quick reminders, if you would. If you'll turn your cell phones to silent, we get started. We appreciate that. If you'd like to speak on a matter before the board today, there are these little white slips out front. I've gotten a couple of them already, but if you do fill one of those out, you can hand it to Cindy and she'll make sure that we call you at the time. Just one other reminder, when you come up to speak, please make sure you're speaking directly in the microphone and start out by giving us your name and address for the record. And with that, we'll get started. First order of business is to receive the minutes from the January 4th meeting, and I do understand we have one correction to those minutes, which was item number 11. It is stated that Donaldson made the motion to deny. I believe Jeff Austin made that motion. Is that correct? Correct. So with that change, I take a motion to receive the minutes.
So moved.
Second.
I have a motion, a second to receive the minutes. Please cast your votes, please. And the minutes are received. Next item is continuance requests or withdrawals from staff.
We have one continuance request for item number 5, case number 14-441, deferred to February 15, 2018.
Is there anyone here that hoped to be heard on that matter today? Case number 14441. Seeing none, I'll take a motion.
I'll move to continue it. I'll second.
I have a motion and a second to continue case number 14441 to February 15th, 2018. Please cast your votes, please. And the item is continued. Do we have continuance or withdrawal requests from anyone here?
David Box, 522 Colcord Drive. Item number 4, case number 14374. I'd ask to move that to the February 15th meeting.
3 questions. 1, why are we continuing the case?
So the reason we've been continuing it the entire time is we have a protester that owns the abutting property. And both sides have now come dangerously close to an agreement. Part of the reason it was denied at the UDC was the presence of the protest. We believe we're going to be coming to you now with everybody, in step and happy about the project. There's one document that needs to be drafted and recorded to make that buttoned up and final. We believe that will be done next week. I said let's just move it one more time to the 15th, which should solve our problems.
Do we expect to have a full board at that meeting?
We do not. So one thing I'd advise you of is, brought to my attention before the meeting, I know we will have one member that is absent for 2 meetings in February, and then I will not be present the first meeting in March. So there likely, unfortunately, and I apologize, but there probably will not be a full board again until the second meeting in March.
And that's fine. And one of the other issues we have is there is an attorney involved who happens to be at Mr. Donaldson's firm, which would obviously make him have to recuse himself. But like I said, we believe we're all going to be in agreement and won't face any issues if we can move it one more time.
When you say we're all in agreement, we're talking about the owner to the south, not the people that are here to sign up, that signed up.
We weren't aware there were any other folks. There was only one person that had issues at the UDC, and we've been negotiating with them for months and months with their attorney. So if there are other people, we were completely unaware of it.
Okay, so just to formalize it, knowing that information, what would your formal continuance request be?
February 15th.
February 15th. Mm-hmm. Okay. Is there anyone here that wants to be heard on that matter? Oh, okay.
Yes, I appreciate you hearing me today. My name is Kevin Thurman. I live at 924 North Chartel, which is directly north of this property. And basically, as Mr. Box has just stated, it's going to continue again. And my question to you guys is how many continuances are allowed before it is actually voted on?
Well, the first thing I would do is apologize to you in the sense that it's never the board's intention or staff's intention to sort of abruptly continue a case. I think we always want to make sure before we hear a case that all the facts and circumstances, especially with people that protest, especially with people who abut a property at issue, have every opportunity to resolve their issues before they come before this body, because essentially if they do, and we feel like they haven't, in a lot of instances we'll ask that they continue the case.
Mm-hmm.
The second thing I'll tell you is that I agree with you. I think that's why I asked Mr. Box the question, because when we get our file and you see that a case has been continued multiple times.
Since June of
Yeah.
2017, yes.
And there's definitely a sensitivity on our side that you probably left work to come down and make your feelings
Yeah,
known.
numerous
So,
times.
Yeah. And so, again, I apologize for that. I do think, given what we've heard, I'm certainly would be in support of continuing it, but I think he's aware that there won't be a full board present, but the case is going to get heard at the February 15th meeting.
At the February 15th meeting. Okay. Yeah. Thank you very much.
So please call me, we'll meet as soon as possible. Okay, or email me, and we'll get together.
Is there anyone else that wants to be heard on this matter today?
I think there were 2 other questions. You said 3, and that was 1 question.
Well, I lied. I wanted to know why we were continuing it. I wanted to make sure that you knew there were going to be people gone, and then I wanted to make sure I affirmed that with that information, you wanted to make a continuance still for February 15th, which is what I just told Mr. Thurman, so.
Right. Again, I'm a little caught off guard because I was not aware of any other protests. My assumption when I said February 15th was we weren't that concerned about a full board because the only parties we knew that had issues dating back to last year when we went before the UDC was the folks to our south. Can I call my client? Is there a lifeline that I could utilize in this situation?
We'd be happy to move it to the end of the docket if you want us to do that. Is there a way that we can notify Mr. Thurman and others of a settled date? I mean, obviously they're going to get re-noticed,
I'm
right?
going to call my client right now with this new information and let that dictate, I guess, what my request would be on the new date that I would like, if that it comports with what their schedule would allow to.
And second meeting in March is the next time we'll have a full board, is correct?
Well, again, with Mr. Donaldson having to recuse himself from the case, over the next 3 meetings, there's only 3 people here.
Yeah, so what I'm thinking is, if my client's okay with it, the end of March, I believe the conflict will be resolved that would allow him to be here, him being Mr. Donaldson, to vote, because I don't believe there'll be a conflict anymore. And then perhaps there'll be a full board, and perhaps we could work out any issues that might be present with these folks. So if you would permit me to call my client real quick.
Okay, so just to be clear, this would be the March, yes, thank you, March 15th hearing. So we'll just move it to the end?
Okay.
Is that, okay. So we'll push the end of the docket, we'll come back up and vote on the continuance.
I'm also here on item 2. I'm not requesting a continuance, but I'm likewise requesting it be moved to the heel. An issue that is unexpected has popped up, but looking at the heel of the docket doesn't look like it's that far away. So I'm going to...
In fact, it's going to be after the next case, odds are.
Okay. So let me call my client real quick.
And we don't need I'm not crazy, we don't need a motion to move it to the end of the docket, right? Right. He just wanted it to be moved to the end. Okay, so so do make the motion. So I'll make a motion that we, first of all, move case number 2 to the end of the docket. That's case number 14442. Or I need a motion, I guess.
I move that we move that to the hill of the docket.
Thank you, Kevin, for saving me.
Second.
I have a motion and a second to move case number 14442 to the end of today's docket. Please cast your votes, please. And the item is moved. And then I guess I'll go ahead and ask for a motion to do the same thing. Well, we're not there yet anyway, so we can call our first case.
Item number 1, case number 14416, request of Armstrong Development Properties for a variance to the streetscape buffer for a commercial use in the C3 Community Commercial District located at 12100 South Pennsylvania Avenue.
Mr. Chairman, I'm going to have to recuse myself on this one as well.
Give us just a second for him to depart, and then we'll... Okay, you can go ahead and give us your name and address and tell us about your application.
Leanne Farha, 100 North Broadway. Applicant requests that we have the case continued for 1 month. My understanding is that the application will be withdrawn, but we're awaiting written confirmation from our client.
So that would be a continuance to essentially
February 15th, is that?
February 15th?
Yes, please.
Okay. Is there anyone here that was hoping to be heard on that matter today? Seeing none, I'd take a motion.
Make a motion to continue case 14416 to February 15th, 2018 meeting.
Second.
I have a motion and a second to continue case number 14416 to the February 15th, 2018 meeting. Please cast your votes, please. And the item is continued.
Thank you.
Thank you.
Item number 3, case number 14443, request of the Rise for a variance to permit 2 signs located on street right-of-way in SPUD 691 district located at 519 Northwest 23rd Street.
Good afternoon, Troy Humphrey with Land Run Commercial, 114 Northwest 6th Street.
Go ahead and tell us about your application.
Our application is just simply, we redeveloped the Rise, which is located at 23rd and Walker, just at this site. And as a part of it, we're seeking a variance to permit signage along 23rd Street so that passerbys and vehicles could identify that our tenants exist and have a presence there.
There are signs on the buildings today, correct? There are tenant identification signs, wall-attached signs?
There are, but not all tenants have signage. There are tenants on the north side of the property that don't have signage opportunities on the south side. This would permit that.
So this is to give people who don't have direct visibility to 23rd Street but are a part of your development signage on 23rd Street. That's essentially the intention?
That's the intention, but this will also permit those that have signage on south side to have additional street front signage as well. The reason being is that if you look at that, that's a great demonstration right there. You see the box where the arrow pointing down, that's roughly where the sign would be. There's signage on the top above that awning, but it's really not visible as was expected whenever you're in a vehicle passing by. This makes it more visible.
In your application, you referenced the 50-foot right-of-way as an explanation of kind of the hardship aspect. Is that right?
Correct.
Tell me about that.
So the 50-foot right-of-way, in essence, from the street. Well, this property is actually, you may recall, years ago, this was part of the parallel parking area that we obtained the necessary approvals to remove the parallel parking. So that's technically in right-of-way, which is where the sign would be located. That's the genesis of it. Had we not removed the parallel parking, the setback would have been much greater, and there virtually be no possible way for signage, landscaping, and pedestrian walkway through the area. So that was one of the reasons why we did that.
What signage are you actually permitted here? I'm not sure that I saw that.
Which ones are we asking for?
No. What signage would you be permitted? What would you be allowed to do but for this variance? You're requesting a variance to go over and above. What would you be allowed to do here?
I don't think we'd be. I think that's the purpose of the variance, just to be able to put signage there. I don't think.
So you have no signage allowance at all here?
In that spot right there, no.
Okay. I was really trying to make that clear.
Oh, okay.
So, board members, questions for the applicant? Is there anyone else that wants to be heard on this matter today? Seeing none, I'd take a motion, unless there's further discussion.
I'd move to approve the variance.
Second.
I have a motion and a second to approve the variance for case number 14443. Please cast your votes, please. And the application is approved.
Thank you very much.
Item number 2, case number 1442, request for a variance to the required 1,200-foot separation between non-accessory signs in the I-2 Moderate Industrial District located at 7624 West Reno Avenue.
Good afternoon, David Box, 522 Colcord Drive, here on behalf of the applicant. Also with me is Mitchell Brown with the OKC Outlets. Before you is a variance application to the separation requirement for non-accessory signs. As you are aware, the city's requirements differ from state. The state requirements for separation of non-accessory signs is 1,000 feet. The city's requirements is 1,200 feet. When faced with these types of decisions in the past, the answers have been pretty clear. But in this situation, we have what is truly a unique circumstance involved. I've handed you a series of images, the first being the proposed location of the sign, the second being a Google image showing what would be in the northwest corner of this exhibit, a blue box surrounding the Brahms location, and then finally 2 images of a Brahms billboard. So what we have is a little over 1,000 feet spacing between our location and the 2 closest signs. The Brahms sign is permitted as a non-accessory sign, because if you look at where the Brahms is and you look at where their sign is, it is not on the same parcel. However, what makes this unique is that there is a perpetual easement recorded and in place for that Brahms sign. And the Brahms sign is essentially an accessory sign to their store that's at the northwest corner of this development. And when you look at the easement, it is a perpetual sign in favor of Brahms for a Brahms sign. And so for all intents and purposes, this, in fact, is an accessory sign. And so when you look at this development, if it were developed today and needed new zoning, it would be in a PUD. And under a PUD, that Brahms sign would be declared an accessory sign, because the standard language in all PUDs now is that the name or business of any sign within the boundaries of this PUD shall be deemed accessory. So when you take that into account, I believe the Brahms sign effectively acts as an accessory sign. And so I think that is a unique circumstance here, which might warrant the granting of a variance. Yes?
You're saying that the Brahms sign is restricted to Brahms use per the easement.
Yes.
So hypothetically, Brahms could alter that.
No.
Who's the other party?
If it ceases to be used by Brahms, it reverts back to my client.
To the outlet mall.
That's right. The predecessor in interest in 1991 granted the perpetual sign easement and a strip of land for the electricity needed to the sign up what would be, I guess, council. And so, again, that's the unfavorable condition number 1. Pursuant to the terms of the lease agreement, I don't believe that could happen. In the event that Brahms decided they didn't want to advertise Brahms and decided they wanted to advertise something else, they wouldn't be able to do that. It would cease to be operating, and my client, pursuant to the lease, would then have title back to that.
Okay, thanks for clearing that up.
Mm-hmm.
So if Brahms ceases and you get your client gets the title back, what impact would that have on your current variance request?
I don't think any, and I think we could stipulate that we can agree that there'd only be one sign, and we wouldn't have the ability to have both signs. I mean, and that's why I do believe it's unique in that it can only be a Brahms sign. If it's no longer Brahms, it goes away. And so our spacing trigger, you know, the things that we're worried about and the things that Lamar Council is going to get up here and say that this isn't any different than anywhere else, that's what they typically say, is just not accurate here because of this perpetual easement that's recorded and has been in place since 1991. So the reasons that Lamar has been concerned in the past aren't at play in this case.
Board members, other questions for the applicant?
I would just note that under the unfavorables, it points out that the Brahms sign could be changed at any time, and it appears that that's not accurate. Am I correct?
Well, I think we need to be careful. I don't have a copy of the easement in front of me, so I don't know what the language says, and I'm not here to evaluate the private rights of Brahms or the applicant. But I am
Based on the testimony.
Based on the testimony, but I am certainly concerned, and I'd be cautious. I'm certainly going to be cautious about adopting that as having effect on what we do, only in that, again, that's a private issue that we don't necessarily have control over and wouldn't have the purview to review should that change.
So if there's no way to approve the variance request with that unknown, well, I mean, we're assuming that what David is telling us is accurate, but we don't know that for a fact.
There's no way for us to know that.
We could submit, we'd be happy to, it's like I said, it's recorded, so it's a public document. We'd be happy to submit that. But the way it's worded, it specifically references Brahms parcel for a lighted sign. It's very clear what the intent of this was. But if that's a concern, perhaps there's a way, we move it, or you guys have the opportunity to review it.
Well, what I would say is it seems sort of crazy that at some point, right, Brahms, that's at the corner of Reno and Council, wanted a sign and drug an electric line, and you look at it now and you think that, but it was, that entire parcel was all farmland. And Brahms invariably was trying to get visibility, and there was nothing else there to compete with, and now it's a fully developed area. But I do think there is a peculiarity about that as it compares to just a straight discussion about the spacing requirements. But I think before we go down that road, if there's no other questions for the applicant, I'd ask if there's other people who want to be heard on the matter. So, is there anybody who want to come forward? Go ahead and give your name and address. Although, I think I have that.
Bill Hickman. I'm here on behalf of Lamar Outdoor Advertising, 5205 North Santa Fe here in Oklahoma City. Do have just a few things that we want to state. We do object and protest to this variance request for a couple of reasons. First, they could have asked for this to be treated as an accessory sign, an on-premise sign. We don't know if their intention is to advertise for stores on site. If so, they were here in October and asked for a variance and were granted a variance then for many multiple aspects of additional signage on this property, and they wouldn't therefore impact the billboard that Lamar has in the area. But the bottom line is that they are asking for a billboard. There's nothing in this request that limits them from turning around and selling this to a sign company in the marketplace and truly turning it in and operating and has a billboard. So that's what you're approving, and you're going to add another billboard to the market that I know I often hear people don't want, and that's why we're here, is to say we want to know what the rules are and we want to follow the rules. Which leads to the next point. When the owner acquired this property, they knew what the rules were. They knew the parcels that were in place. They knew the PUD that was in place. They knew what the ordinances were as far as spacing. And so if there is any hardship here, it's purely self-imposed and financial, which are not legal grounds for the granting of a variance. From a timing standpoint, which they've tried to allude to with regard to the parcels and how way back in the day this was all one parcel, you take that logic to its logical conclusion, every site in Oklahoma City, in large part, we could make that argument and go way back in time and say, well, at one point in time, this was all one parcel, and this now on-premise or off-premise sign should be considered to be all one and the same, and we could create the same kind of situation that we're arguing about now. Because what I can tell you is there are multiple locations. There's a McDonald's, Cracker Barrel, Travel Stop, on-premise looking signs that are billboards, though, that have state permits and are treated by the city as billboards. Why do they do that? Because of this spacing requirement. It provides a buffer intentionally between these signs. And so if we're going to go down this slippery slope, there are many other places out there in this community, just so you understand that. This is not a unique deal, where there are on-premise signs. Like I said, Cracker Barrel, Travel Stop, McDonald's, the three in this immediate area that are permitted as billboards, that are treated like billboards, and could go back in time and say at one point in time they're all part of one parcel and should be treated as on-premise. Currently, they're not on the same parcel. This Brahms sign is not on the same parcel, and it's therefore a billboard. But with regard to Lamar, I handed you a little aerial map. The Lamar sign is on the east side. Where they're wanting to put their sign would be within approximately 1,000 feet. Would make our sign non-conforming at the city and state level. Lamar has an easement at this location as well. So it negatively impacts Lamar's sign and property rights by making it non-conforming, meaning that if something happened and we had to take the sign down, we would not be able to rebuild it. And that's why Lamar is objecting to this, this request amongst other reasons. Additionally, as indicated by your staff, the sign spacing was changed by agreement and cooperation with the industry and the city in 2008 to 1,200-foot spacing. And if we're not going to apply that consistently, there should be an extraordinary reason. In this instance, there's not any type of extraordinary reason to justify it. And then finally, with regard to the Brahms sign, it's not an accessory sign. It's a billboard. It's permitted with the state of Oklahoma as a billboard in 1991. It's been treated as a billboard all along. On the parcel development that they were referring to, you can see there's 5 parcels between where the billboard sign is and the Brahms. It's separate and distinct, and I actually have a copy of the easement document, and with all due respect to Mr. Box, I don't read where it says expressly that it reverts back to the original owner. And furthermore, it wasn't too long ago that they amended the easement agreement, which can be amended. So you cannot and should not make a decision based on whether or not this Brahms board will or will not go back to the owners. It is a billboard right now. It's always been treated like a billboard since 1991. It was permanent with the state of Oklahoma in 1991 as a billboard. It's a billboard today as you're making this decision. And so on behalf of my client, Lamar, we would request that you deny this request. You would be adding another billboard sign to the inventory in the city of Oklahoma City. It goes contrary to the intent and purpose of the spacing requirements that were agreed upon by the industry and the city, and it negatively impacts directly Lamar's property rights. Thank you.
Thank you. Is there anyone else that wants to be heard on the matter? You want to?
Yeah. If Mr. Hickman was not able to find the paragraph, I'd be happy to read into the record of the easement that he is in possession of. The parties mutually hereto agree that should the grantee abandon the easement for the purpose above stated, again, a Brahms sign, then the easement shall revert to the grantor, its successors, and/or assigns. So to me, it's fairly plain language in an easement that should it cease to be operated for the purposes stated within the easement, a Brahms sign, it absolutely will revert to grantor or successors, in this case, my client. So we do believe it makes it a unique circumstance. The references made about Cracker Barrel and McDonald's, I'm not sure if those are Lamar signs. I'm not sure if they're similar language. But to me, this is a unique circumstance that I have not seen in these spacing issues because of the very specific easement that's recorded allowing the Brahms sign.
They have a potential solution. I saw that program. It just, with regard to the easement, it just says abandoned. It doesn't say it can be sold. It doesn't say that Brahms can't sell to somebody else, but we're not here to argue the private rights. If they would move the location so it's more than 1,200 feet away from Lamar's sign, that's why I came back up here, because I don't know if they can do that or not, then it doesn't make Lamar's sign non-conforming. We still don't think it's appropriate, but that would lessen our opposition, if you will, if they would get 1,200 feet away from Lamar's sign, which if they're going to say that the Brahms sign is an accessory sign, they can put it right next to the Brahms sign.
I think we understand that. I think if they move it, they still have a problem in that the sign is still within, it still conflicts with the 1,200-foot spacing requirement, which is all we care about. We don't care here what the state says. We care about what the city ordinance is, and that says 1,200-foot spacing. So we got the same issue. So is there anyone else that wants to add anything that we don't know about? I'm assuming not. Board members? Questions or comments, thoughts, motions?
Yeah, I mean, just to get a couple of comments on the record, I think there are a lot of uncertainties here. I do think that the hardship it seems to be self-imposed, so I know I'm hesitant to feel comfortable supporting it unless, maybe there's some things I'm not seeing that the board can bring to my attention, but that's kind of where I stand right now.
I can't help but wonder how Brahms got that sign. Presumably it's because they carved out the corner from the larger parcel, got their accessory signage, and then had this separate parcel that they could get the sign. And again, it was all farmland. But it does bother me. The intention of the ordinance is very clear. And it's very stern. It's not meant to be gray. It's intended, its very purpose is to create a larger separation requirement than what the state has. And so it seems fairly clear.
I have a question. there was a discussion that they would not have an objection if you went to 1,200 feet. Can you possibly move that sign to 1,200?
No, I don't think we can, because then we violate the 1,000-foot spacing requirement to the Brahms sign. And so,
But which, to be clear, is you've got a state problem there.
That's a
state
state problem.
separation
That's right.
requirement is the issue.
Why do you need the sign? What's the purpose of the sign, and how's it going to be utilized?
it will be a non-accessory sign. I mean, it is, Mr. Hickman raised some questions as to whether or not we knew what non-accessory meant, and we do. We understand that that would allow us to advertise for people that aren't within the property, so yes, non-accessory. The intent is the same intent that Lamar or any other sign company has, and that is to generate additional revenue, to help the ability of the outlet mall to be successful.
I'm going to share the concerns of the others and make a motion to deny the application 14205.
I'll second it.
I have a motion and a second to deny case number 14442. Please cast your votes, please. And the application is denied.
Thank you.
I believe you did say different case number. It's okay. It's okay. It's all right. Right in the record. We're okay.
We're back to item number 4, case number 14374, appeal of the decision of the Urban Design Commission regarding denial of certificate of approval for UDCA 17-00001, located at 908 North Chartel Avenue.
We'd ask that we move it to the February 15th.
February 15th. Okay.
Can't get a hold of my client, so make an executive decision.
Okay. I would need a motion.
I will ask, I know the gentleman is here that was going to protest. Was there anyone else? I mean, I assume that the other protestants that would otherwise have been here were notified of the potential continuance and aren't here today?
Yeah, and he had mentioned that he had sent letters to staff. Like I said, caught me way off guard. We've been negotiating this thing for, I think, 8 or 9 months with one person and had no clue that there was any other concern. So he's got my card. He's going to email me. I'm going to send him to my client today so they can go figure out what his concerns are. And so I apologize to the board. We've been continuing it unaware that we were impacting anybody else, operating under the assumption that the only person that had an interest was represented, and we would work back and forth with their lawyer to reschedule these things. So I apologize. But yes, presumably other people, if they were interested, would have. And the lawyer representing the lady to the south lives in the neighborhood, so I know that Sosa neighborhood is aware of the schedules that are being worked on.
Yeah, that was my only concern with not continuing it, is not everyone who has an interest, I don't think, is present today.
Mr. Wilson, the clerk gave my wife the copy that I submitted to the Board of Adjustments, that the Sosa Neighborhood Association has written you a letter.
Yes, we have that. It's in our
Okay.
record.
Yeah. Just wanted to make sure that's clear. And you have my letter also, because
Yes, sir.
he
We
gave
did.
me a copy of that. Right, exactly. Yeah.
I think Sam's, concern is just making sure that there's a full notification of everybody that has an interest in this case. If there's no further discussion, I'd make a motion to continue case number 14374
Second.
to February the 15th.
I have a motion and a second to continue case number 14374 to the February 15, 2018 meeting. Please cast your votes, please. And the item is continued. Short and sweet on that.
If there's no other business, I would make a motion to adjourn.
Is there any other business, additional items, or citizens to be heard, or comments? Any? Seeing none. Have a motion.
Second.
Have a motion and a second to adjourn. Please cast your votes. We are adjourned.